All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning. We'll take up case number 22-338, Orme versus State of Florida. And I apologize if I didn't pronounce your client's name right.
Good morning, Chief Justice Muniz, Justices. My name is Barbara Basharis. I'm here representing Roderick Orme. I've asked to reserve 5 minutes of my time for rebuttal. Thank you. Mr. Orme is asking this court to consider the lackey claim that being under sentence of death for nearly 3 decades is itself cruel and unusual punishment, rising to a level that violates the United States Constitution and therefore, by virtue of the conformity clause, this state's Constitution. We are aware that this court has rejected similar claims in the past, but believe that there are reasons to reconsider that in light of the circumstances presented by this particular case. Mr. Orme has twice been sentenced in a manner later found to be erroneous or unconstitutional. He has never received a unanimous jury verdict. In fact, his first death sentence was handed down after a jury recommendation by a vote of 7-5, which under no stretch of the imagination would satisfy the standards that we have in place today. Moreover,
well, Mr. Orme decided he didn't want a jury in this resentencing. Isn't that correct? I mean, he was very explicit about that.
Yes.
And there was, I mean, you're not raising an issue about his waiver of the competency.
No, Your Honor, we're not.
Or anything about the waiver. So he waived the jury, and it seems like he, at least at that point, he was willing to accept the responsibility for the crime and accept a death sentence if the judge thought that was appropriate. That's what he said, right?
I believe that is exactly what he said.
So he's changed has he changed his mind now?
Mr. Orme has not waived his appeal. There's a difference between being willing to accept the sentence of death and acquiescing in giving up the appeal to which he's entitled. He is not waiving the right to have his sentence reviewed by this court. And given his waivers of mitigation, of his presence of a jury at his third and most recent sentencing, the ground of a lackey claim, which was argued in the trial court, is the ground that is present for this court to review today.
If I could just follow up on the distinction you drew in your answer to Justice Kennedy about there being a difference between his acceptance of responsibility and waiver, which you don't contest, and his not giving up his right to appeal his sentence to this court, a distinction that I see, but now I want to press on a little bit. What remedy do you seek?
The remedy in this case, based on the lackey claim, would be to find that his sentence is unconstitutional and to sentence him to life in prison, which would still be a severe punishment fitting the crime that he has acknowledged.
Doesn't that make doesn't that dissolve the distinction you just made? I mean, if in fact the remedy that you are seeking on his behalf is contrary to the remedy that he waived below, aren't we left exactly where you were before before Justice Kennedy asked his question, which is sort of us not being able to make sense of what he really wants here?
Respectfully, no, Your Honor, because he didn't waive the right not to be killed. He waived a jury. He waived mitigation. He put his fate in the hands of a trial judge. But it was certainly possible at that point, although highly unlikely, that that particular trial judge could have sentenced him to life based on the combination of aggravating and mitigating circumstances. So no, I would say that he did not waive the right for a life sentence to be considered. And that's what's really in front of the court now. He didn't do that. I'm sorry.
The Lackey claim that you're raising here today, the whole premise of it derives from a dissent written by Justice Breyer back, 1998?
I believe it was first Justice Stevens in 95 and then Justice Breyer in 1998.
So other than those dissents, has there ever been a majority opinion from the United States Supreme Court adopting this Lackey claim that if someone sits on death row too long that it becomes cruel and unusual to execute them?
No, Your Honor. There's been no majority opinion either adopting or rejecting that. The court has simply refused to hear a number of cases, has allowed the decisions of lower courts to stand, but the court hasn't addressed the issue.
And in this particular case, how long has Mr. Orme been on death row?
He was first sentenced to death in 1993 after his first trial. So that was
Has any other, kind of in line with this question, has any other state Supreme Court adopted the Lackey theory to give relief?
Not yet, Your Honor. It has not happened.
So if we adopted this theory, we would not, go against the precedent we have set.
Correct.
And we would be a singular outlier if in that respect.
We would be, yes, although Florida has been an outlier in other respects too, and that doesn't determine whether the claim is valid or should be considered by this court.
So your position on the conformity clause is that it doesn't preclude us from being innovators on an issue as long as there's not a Supreme Court, U.S. Supreme Court decision that has directly addressed the same issue that's being raised?
That's correct, Your Honor, that there is nothing to conform to at this point in Supreme Court jurisprudence. We have,
other than on this precise issue, but the analytical framework we would need to conform to, but if it hasn't been considered in the context of this specific issue, then you think that we have free rein to do our best to apply the framework and reach whatever conclusions
and
we
reach a
think.
conclusion, yes. And at that point, if the United States Supreme Court disagrees and wants to take it a step further, that court would be able to do so on review. But the court has not precluded a Lackey claim. The court has simply not recognized it to date. And one of the things that has happened and continues to happen, as documented by the Death Penalty Information Center, is that the length of time that people are being kept under sentence of death has slowly and steadily continued to rise in recent years. The age of prisoners on death row has slowly and steadily continued to rise. And at the same time, exonerations have continued to happen. According to the Death Penalty Information Center, exonerations often take anywhere from 20 to 25 years before they work their way through the justice system, and somebody who is deserving of that can get the remedy that he or she needs. Now, of course, that exoneration is not an issue here, but that is the backdrop against which I think it's appropriate and important for the courts to begin looking at the length of time we're keeping people subjected to these the conditions and the procedures.
What's the limiting principle you have to offer this court in the rule you're asking us to adopt? How long is too long for Lackey purposes?
I think, Your Honor, that it would have to be based on the circumstances of the case, the age of the defendant at the time when they were sentenced, the reasons for the delay, I think would be a part of it. The court has always considered that when rejecting those claims. I think it would still be part of the analysis. Anytime you try to draw a bright line in these cases, you're going to get a case that you can't
you're
decide.
asking us to innovate. You're asking us to outlie. You're asking us to proclaim a rule. So proclaim it for me. What is the rule that you're asking us to adopt exactly?
Well, in this case, although the court has rejected similar time periods in the past, we would be asking you to hold that being under sentence of death for 30 years is itself cruel and unusual punishment. And
But not 29.
Again, that's the line drawing, Your Honor.
I guess what I'm getting at is obviously you're not asking us to draw a very satisfying rule, are you?
It's not a very satisfying rule to keep people on death row for decades either, without any finality to their cases for them or for the victims, for society in general.
But, I'm just struggling a little bit here, because to the extent that it is cruel and unusual punishment, it's done. That has happened. Mm-hmm. And so I don't even know how your remedy actually corrects what you say is wrong.
Because, Your Honor, at the point in time that the defendant or the inmate is no longer on death row, then the cruel and unusual punishment has ceased.
Well, it would cease when the execution is carried out.
Mm-hmm. That's true, but we don't know when that will happen. These time periods, as I said, are creeping up and getting longer and longer.
Well, but again, it just seems curious to me that in a case where the defendant basically said he wanted the death sentence, that we're here arguing about this, and arguing that this has all taken too long, when this has come here in this particular manner based on these particular circumstances.
I do have to respectfully disagree that Mr. Orme ever said he wanted the death sentence. I think what he said, and again, this you can watch this on the internet, he said he doesn't want to die, but he's willing to accept the sentence that the court hands down. So he is not seeking to die. You have seen defendants in this court before who actually have requested execution. This is not one of those
Well,
cases.
he did say, and I have the transcript here, and what is reproduced from the transcript and the court's order. After he says that he doesn't want to die, he's not suicidal. He does go on to say, I'm asking basically to have my death sentence reinstated. Mm-hmm. He did say that.
He did say that because it had been handed down previously, and that was what it issued.
And Your Honor, I'm hoping that you, Your Honor, will go ahead and agree with my claim, my motion. Go ahead and just reinstate my death sentence. That's my goal. Mm-hmm. Okay.
Yeah. Again, along with the fact that he clearly said he's not suicidal and doesn't want to die. His asking for the reinstatement of his sentence has more to do with his acceptance of responsibility and the fact that he, as he said, sees that as a way to bring justice and bring this case to a close. But as was argued in the trial court, a definitive life sentence would also bring the case to the close. A definitive life sentence is subject to less review, less scrutiny, less collateral attack than a death sentence is. And so the goal of finality doesn't require killing Mr. Orme. The record also shows, and I think it's important that this court consider that Mr. Orme is not the person that he was in 1992 when this horrible crime happened. He's not the person he was in 1993 when he first was sentenced to death. The expert report at his most recent sentencing, although it found no current mental health issues requiring consideration as additional mitigation, noted that he is no longer abusing substances, that he's no longer experiencing mental health issues. He's had no disciplinary reports since he stopped taking psychotropic medication back in 2012, over a decade ago. And so the interests that we have in this case.
When was his bipolar disorder first diagnosed?
Your Honor, I don't remember the year it was first diagnosed, but I know that the failure to further investigate it was the reason that his first sentence was overturned on collateral attack, which would indicate that there was evidence of bipolar disorder going back to the 1990s.
Well, but that diagnosis has been disputed, correct?
The diagnosis is a primary diagnosis that was noted in the expert report at his most recent sentencing. So that's the most current.
Weren't there experts that disputed the bipolar disorder diagnosis? I mean, he's got problems, but that was disputed.
At his resentencing.
Yes.
Yes, his first resentencing, yes.
I mean, I understand why you would make this as kind of in a clemency context, why you would bring this up, but what possible relevance does this have to the legal argument that you've raised?
Because, Your Honor, it goes to, and I'm going to go back to those original Stevens and Breyer dissents from which these claims have sprung. It goes to the purposes that we use to justify executing people, retribution and deterrence. And when you have somebody who has shown that he is not the same person, he hasn't committed additional offenses in prison, let alone violent offenses. He hasn't committed nonviolent offenses. Even his disciplinary reports were for substance abuse.
But it sounds like, though, that would transform courts, because theoretically you could keep raising this as some kind of new evidence or something. I mean, that would basically turn courts into de facto kind of perpetual clemency boards for as long as people were on death row.
I don't think so, Your Honor, because it would happen in the context of a resentencing, which Mr. Orme had, because this court had maintained a jury system for so long that was not sufficient.
Wouldn't you be able to keep saying, this person's been subject to a death sentence, they're not the same person anymore, you're violating their right, et cetera, et cetera? I mean, wouldn't you just keep making those arguments at every kind of whatever increments of time you thought were appropriate for kind of relitigating it?
Your Honor, I'm not aware, outside of the framework of direct appeal and collateral attack on a sentence, I'm not, if you're suggesting that somebody could, I guess, bring repeated habeas petitions saying that they had changed.
I mean, wouldn't you characterize it as
really
kind of newly
issue.
Discovered evidence, essentially, that you could keep litigating in a 38?
No, I think this is evidence that was in front of the court at the most recent sentencing. It's in the record, and so it's appropriate to consider. And again, it does go to the purposes for which we say we execute people. Those purposes, the goals of retribution and deterrence diminish over decades. And so, especially when you have a defendant who has not committed other violent offenses, who is not the same person he was when this offense took place, it is worth asking the question, does imposing a death sentence on this defendant serve any goals? Or is it just, as Justice Stevens said, the pointless and needless extinction of life with only marginal contributions to any discernible social or public purposes? So, and if I could reserve the remainder of my time. Thank you.
Good morning. Steve Woods on behalf of the state. May it please the court. Beginning with the Lackey claim, I suppose I'd begin by, it is hard to add anything to what's already been said about these Lackey claims. This is a facially invalid claim. The time on death row, however prolonged, this cannot constitute a violation of the Eighth Amendment. Even if there were, say, 30 years, even if there were some excessive duration that did constitute a violation of the Eighth Amendment, still, Mr. Orme could not prevail. The rejection of several Lackey claims these are Lackey claims from defendants who have been on death row longer than Mr. Lackey. In Valle, the defendant was on death row 33 years. in Ferguson and in Lambrie, over 30. So even if there were, and there is not, but even if there were a period of time that were too excessive, he still could not prevail. We'd also point out the defendant contributed to this delay. He cannot distinguish the precedent. There has been no reason put forth to depart from the controlling precedent on this issue. The defense says, well, you should consider my circumstances. Of course, I've changed, and there was this 7-5 non-unanimous vote, and then there was an 11-1 non-unanimous vote. And he points out, well, I'm not responsible for all of the delay. We respond to that by pointing out that, I mean, first, that there simply are no circumstances that could be sufficient. No circumstances can be relevant. And even if they were, the entire issue would have to be resolved by Article 1, Section 17. He cannot prevail, given the conformity clause.
How does the conformity clause bind us in this case, given the silence from the Supreme Court of the United States?
Well, given this, there must be a perfect, as you say, the federal Supreme Court has not spoken on it. And so, given that there must be a perfect overlap between the Eighth Amendment protections and the cruel and unusual prohibition in Florida, this court could not do it because it wouldn't be perfectly in line with what the federal Supreme Court has done.
So you think that we're precluded from applying the Supreme Court's own standards to an issue that they haven't directly resolved? I mean, so that kind of gets to this whole kind of innovation question. I mean, do you view the conformity clause as requiring us to essentially sort of sit back until specific issues are resolved by the Supreme Court and then someone can bring sort of the identical claim here? I mean, because it seems like just on the face of it, as long as we're analytically going through the same steps as the Supreme Court would in an Eighth Amendment case, and as long as we're not reaching an answer that's different than what they've reached on the same issue, that the conformity clause wouldn't prevent us from being the ones who are the innovators.
Your Honor, the conformity clause is a secondary argument. We primarily rely on this court has addressed this question no fewer than 12 times. 3 of them have been for defendants who have spent longer on death row than Mr. Orme. The conformity clause, in my view, if this court were to say, well, under the conformity clause, a lackey claim is valid, that would be a non-perfect overlap between the Eighth Amendment at the federal level and the Article 1, Section 17 provision of the Florida State Constitution. If I could briefly address Issue 2. Issue 2, this issue about whether sufficiency and weight, I'd just briefly point out that under the clear precedent both from the federal Supreme Court and from this court, there's no question as to whether sufficiency and weight are elements that need proof beyond a reasonable doubt. Again, there's been no reason stated to depart from the precedent that is controlling, and no reason to revisit what has been well settled. It is only the existence of an aggravating factor that must be proven beyond and to the exclusion of every reasonable doubt. And if there are no questions, the state would very respectfully ask that this court affirm. Thank you.
Thank you.
Thank you, Your Honors. As to Issue 2, which was raised for preservation purposes, I'm going to defer to what's in the briefs. I would just like to point out that this case illustrates the brokenness of our death penalty system. We cannot impose it fairly without allowing people to attack their sentences. And Mr. Orme did attack his sentence for very valid reasons. He didn't file frivolous appeals. He didn't bring frivolous claims, and his sentence was overturned twice. we can't execute people more quickly without running the risk that somebody who either was sentenced improperly will be executed, or somebody who is wholly innocent will be executed. And so that is the conundrum that is before this court. We simply suggest that in this case, based on the situation Mr. Orme presents, that he has already been punished, and that to keep him on death row would be cruel and unusual. Thank you, Your Honors.
Thank you, and we're adjourned.
All right.